Welcome to Regulatory Ramblings Briefs. Happy New Year. Our guest today is Jamieson Kirkwood. He's a postdoctoral fellow with the University of Hong Kong's Faculty of Law, and he's recently written an article with Julien Chaisse of the City University Law School. It's entitled Tokenised Funding and Initial Litigation Offerings, the new kids putting third-party funding on the block. And with that, I haven't gone through the entirety of your paper, but I have given it a cursory look. And if you could tease out in your own words, what's your central argument, and what are you advocating from a policy perspective?
Right. Well, basically, the third-party funding market is already pretty big. Zion market research, for example, have estimated that it will grow to $20 billion in the next few years globally. And the gist of the article is that tokenization of litigation funding will accelerate the growth and make it even bigger. From a policy perspective, we're not particularly advocating anything new. We just would like to present to the audience that this is happening.
Okay. So you're not advocating any changes in the rules or regs just yet?
No, I mean, security tokens which are involved in the tokenization process are pretty well regulated in most of the major jurisdictions. I think perhaps what we'd like to see, and what's actually not in this paper, because this paper is not about regulation per se. We'd like to see perhaps in the future a kind of global oversight body, because there's a slight lack of harmony in the regulations, say the US, Singapore, Hong Kong, other jurisdictions.
Regulatory turf wars abound. I guess it's a recurring theme in the field of financial law, and when it comes to myriad topics. But you put it a certain way that blockchain technology is disrupting the monetization of litigation claims through tokenization. Is there something inherently destabilizing or revolutionary about tokenization?
Well, what it does, and if I can quote you from the paper, it principally does three things. It makes it easier for the issuers of litigation funds to get financing, to get funds. It makes it easier for investors to get access to investments. And it also allows for asset fractionalization. And fractionalization is a kind of a brand new thing in the tokenization space. If you look at like cryptocurrencies and Bitcoin, they're down to, the very, very low percentiles, like one Satoshi, 0.000008, or Bitcoin is a Satoshi. So potentially that can also apply to litigation claims. You could have a very small amount of a claim or a very high amount of a claim.
Akin to the way people trade fractions of shares.
Yes.
Yeah.
And it would be far easier to do that online via a kind of a crypto exchange or a security token exchange, as opposed to going on a regular brokerage account, where you might only be able to do half or a quarter of a share at best.
Right. But you point out that this might open up this quote-unquote potential investment field to people beyond just accredited investors. So I'm thinking, is it possible if more people come to view litigation financing as a good or potentially lucrative investment, might the net result be more litigation? And I'm thinking about it from a Hong Kong perspective, because that's where we are. The greed in this town is palpable, and having grown up here, I can tell it's not just human nature. There's something in the Hong Kong psyche about fast money is the way to go. And people jump on bandwagons the way they did with the Lehman mini bonds saga in 06, 07, 08. And they may not necessarily be prepared for the outcome. Could this lead to more litigation if people start viewing it as a viable investment vehicle?
Well, there's a couple of things to say. I mean, firstly, the short answer is yes, because the returns are touted to be massively over the returns of other asset classes.
Right.
In my paper, I mention up to 85%. And if you're looking at, the returns on savings as, 1 or 2% at best, 85% is a massive return. However, traditionally the litigation funders, they have a team assessing the lawsuits. They'll only take on claims they think they've got a good chance to win.
Meritorious, yep.
Meritorious claims.
Yep.
So therefore, they'll take on claims they assess 50, 60% likelihood. They won't just take on any kind of frivolous claim. So even if the investors want to fund every kind of claim, it won't be put forward by the funders themselves. And the final thing to say is that, it's up to the court to dismiss the lawsuit. It's not up to the funder to dismiss the lawsuit. The funder is providing a vital role in access to justice. And there are many claims which wouldn't be allowed to proceed without having the access to justice, which has been enabled by third-party funding.
That's what always struck me when I compared, say, the common law systems in the U.S. to elsewhere in the Commonwealth, that because of contingency fees in the U.S., that the average person, will they necessarily always get justice? No, but can they perhaps have a shot at some modicum of it? Yes, in that system. Whereas here, the cost prohibitiveness of the system, of bringing suit, bringing action, almost seems to preserve the status quo and protect the wealthy and the established interest from ever fear of being dragged into court, because the average person simply can't afford it. And and here, and as in many places in the world, the loser pays, the winner's costs.
Exactly. So third-party funding in that sense is revolutionary because it allows the little guys to have a chance. And tokenization is a further step. It's revolutionary within a revolution. So it's a further step in allowing little guys to have a shot.
But see, things like litigation funding and class actions, I mean, they are scorned and belittled by the establishment legal community in this town and the wealthy that they serve. Maybe attitudes are changing now. You're starting to see more of a sense of doing what's right in the interest of the community, more of a social justice bent. Do you see attitudes changing in this town?
Definitely. I'd refer you actually to my paper, to a paper from my colleague, Professor Chan Ekin from Durham Law School, who looks at the regulation of Hong Kong in the third-party funding space. And he notes how it's been changing since 2017, and especially up until 2019. The main reason being investment arbitration. Hong Kong wants to be the hub for investment arbitration. It simply cannot allow other jurisdictions like Singapore or London or other places to dominate the market because they allow third-party funding. So Hong Kong has had to follow that up and allow third-party funding. So I think attitudes are changing. And with Hong Kong also being a self-proclaimed hub for crypto, I don't see why there'd be any issue with tokenization. In March 2019, the SFC in Hong Kong, announced that security tokens are very likely to be classed as securities under the Securities and Futures Ordinance.
No, that was an important step. I vaguely remember when they did that. It didn't register with me the full significance of it. As you're adding context to it, so the significance seems more striking now. In your paper, you also talk about the regulatory challenges and the moral hazards that arise in this space. Could you flesh that out a bit more?
Yeah, this, as I've said at the start, this paper is not specifically looking at regulation
Per se, yeah.
per se. It just touches upon the regulation in kind of the six most important jurisdictions for security tokens. Previously, Hong Kong was not one of them. So this paper doesn't look at the Hong Kong regulations as such. Hong Kong is becoming more important. In terms of the moral hazard, I think, there have been a lot of bad actors in crypto. We've seen a lot of problems in initial coin offerings, also in crypto exchanges. On another episode, we'll talk about FTX and these things. It's important to point out that security tokens are quite different, and actually they've been embraced for their, the way they cooperate with regulators and auditors, and so there's less of a moral hazard in security tokens.
Coming back to the point about third-party litigation funding offers people who might otherwise not have had a chance at justice, a fighting chance of having their day in court. And I think that resonates with a lot of people because certainly in the last 10, 12 years, you've seen an increased number of pro se litigants, people representing themselves. And it's a mess. They do the best they can. I mean, the clerks of court do their best to guide them, but people do so because they frankly can't afford, the services of a lawyer, and legal aid is next to non-existent in this town. And the profession, when you raise the topic with them, they say, "Why doesn't the government increase more funding?" I mean, that's their position. But okay, let's play that out. It gives more people a chance to sue because they can get the funding to bring a case. But as with many things in life, it's a double-edged sword. Does that not lead to a more litigious society and, clogged up court dockets?
Well, actually, what third-party funding and especially tokenization does is actually it helps to bring the justice system into the 21st century. And yes, there are clogged up court dockets, but that's not caused by TPF. In fact, TPF and tokenization, it helps to allow streamlined dispute settlement and streamlined operations. Things can be placed in future on blockchains, and they can actually be resolved in a far more efficient way. I'll be researching and writing a paper later on this year about digital dispute resolution, and I think this is an important part of it. I was recently talking to Professor Reyes, also of Hong Kong University, not with us anymore, but he did his PhD here and he still comes to present. He was saying, for example, in arbitration, everything can be put on the blockchain.
That's my understanding.
All the kind of up until the decisions of the arbitrators, that could be in the blockchain. So the arbitrators don't have to repeat all the previous steps. They can just make a decision which can be added onto the blockchain. Also, in terms of digital dispute resolution, we're going off the topic now. Also, in terms of digital dispute resolution, we were looking at oracles. Is a no disrespect to the court clerks or even the judges or anything like that, but are they the best placed person to adjudicate? Should it not be, a specialist in that particular field or area to maybe not adjudicate, but to provide an input? And that's what an oracle does. An oracle provides an input. So it helps to bring so getting back to the topic, third-party funding and tokenization. Now, far from clogging up the system with frivolous lawsuits, which I suppose if unchecked it could do, but it actually helps to bring the justice system into the 21st century.
I mean, from having spoken to a number of people in the legal profession, the judges, the courts, if they can get by without taking on more of a burden, they will. So, frankly, they don't want to necessarily deal with more cases. But in the time we've got left, I mean, is there anything you feel you wanted to discuss that we haven't? I mean, is there anything you'd like to stress?
Yeah, I think there was quite an interesting, mention of the case in the US, where there was a cannabis farm, basically, Apotheo LLC against Kern County, which was kind of the first initial litigation offering in the world.
That was a federal case, wasn't it?
That's a federal case.
Yeah, Ninth Circuit.
And that was interesting because they were raising money and issuing tokens to the investors. So it's a third-party funding case as well, and tokenization case. Issuing tokens, I believe, is on the Avalanche blockchain. Those tokens are not tradable yet. I think 350,000 US was raised by the cutoff date, which was, I think, March of 2022. So 1 year later, so from this March, those tokens will all be tradable. And as I understand, the actual terms of that case mean that the tokens will kind of like increase in value the longer the case goes on, when there's more likelihood of a payout.
Yeah.
So we could actually start to see some trading. So I mean that's very interesting, quite promising from a tokenization perspective.
That they become a financial instrument being traded. Yeah,
Exactly.
Yeah. That's intriguing. Well, thank you so much for your time, Jamie.
Very welcome.
Appreciate it. And to our viewers, thank you. Until next time.